The principal contention which is sought to be put forward by the counsel for the revisionist is that in a revision which arises out of an order passed by the board under Section 12 of the 33 Act, rejecting the bail application, which has subsequently been affirmed in an appeal under Section 101, the complainant/victim cannot be said to be a necessary party entitled to an opportunity of hearing. The opinion of the division bench that the counter affidavit having subsequently been filed, stay/modification could be sought of the interim order cannot be considered sufficient justification to have declined interference. When a position, in law, is well settled as a result of judicial pronouncement of this court, it would amount to judicial impropriety to say the least, for the subordinate courts including the high courts to ignore the settled decisions and then to pass a judicial order which is clearly contrary to the settled legal position. While expressing the aforesaid view, we are conscious that the powers conferred upon the High Court under Article 226 of the Constitution to issue to any person or authority, including in appropriate cases, any government, directions, orders or writs including the 5 prerogative writs, for the enforcement of any of the rights conferred by Part 3 or for any other purpose are very wide, and there is no express limitation on exercise of that power, but, at the same time, we cannot be oblivious of the rules of self-imposed restraint evolved by this court, which every high court is bound to keep in view while exercising power under Article 226 of the Constitution. It is true that the rule of exhaustion of alternative remedy is a rule of discretion and not one of compulsion. But it is difficult to fathom any reason why the High Court should entertain a petition filed under Article 226 of the Constitution and pass interim order ignoring the fact that the petitioner can avail effective alternative remedy by filing application, appeal, revision, etc. and the particular legislation contains a detailed mechanism for redressal of his grievance. Further, no copy of the enquiry report of the enquiry officer dated 8 September 1993 was supplied to the petitioner for submitting his objections against the same. The enquiry report aforesaid was obtained ex parte and accepted ex parte by the respondent number 1, the executive engineer. The punishment order, therefore, is absolutely against the law of fair disciplinary inquiry into the misconduct of misappropriation of public money by the government servant. Learned counsel for the revisionist has submitted that an application for bail on behalf of the child in conflict with law is firstly required to be filed before the board under Section 12 of the JJ Act, and as per the statutory provisions there is no requirement to provide any opportunity of hearing to the complainant/victim while deciding the bail application. Against the order of the board rejecting the bail application, There is a provision of appeal under Section 101 which also does not stipulate providing of a hearing to the complainant/victim. It is submitted that in a case where the application for bail of the child in conflict with law has been rejected under Section 12 of the JJ Act, and the appeal preferred there against under Section 101 has also been turned down, the remedy thereby filing a revision before the High Court under Section 102 of the 33 Act.